Now, we have a discussion of accountability and democracy, which is developing and very intense right now. There was a precursor to the current discussion in the early 1960s. And the historian Yasar Seif, which then basically presented a modern analysis to support the view which would have been current in the late 19th century. This is court review, is the reaction's attempt to secure the positions against emerging democracy and modern regulation of an economic environment. My uncle, Yuval Perez, was then the proponent of the other view. Actually, these were general legal principles. He did, however, not very much envisage any strong rights protection. What they discussed here was, of course, on the basis of the cases, and the cases that Jean-Louis pointed to were about the restrictions on property rights which came in legislation, and review was about restricting those restrictions. Rune Slagstad is then an author who comes in from the left. You mentioned he comes in from the left, and he then embraces, if you like, the rights thinking at the time. He has problems, of course, because all the rights are about property rights, and of course he thinks rights in a different way. He thinks individual rights, and he thinks the rights of the weak, and that leads you immediately into the juridification, which to some extent is now coming as a discussion in a Norwegian context by some people placed centrally in government and in the political system who are worried about the limitations on their discretion as a consequence of internationalization and domestic constitutionalization. And they are concerned about rights society and the role of courts, and they would then put in all kinds of, as I will give some examples on, limitations on the effect of European Union law, European human rights law, and domestic constitutional law. And the argument is very parallel. It does, I'm afraid, cover, or it includes all my colleagues in the law faculty, because the law faculty is then either constitutional lawyers who want to protect the autonomy of constitutional law, or the European Union lawyers who then basically work with limiting the effect of European Union law in Norwegian law, because that's a natural task, it seems like, for an academic, or they are not particularly interested in individual rights. It is a very, to me, still very difficult to understand setup. But basically, the whole academic discourse, I'm the only one who writes about giving, in an analytical way, trying to give some support to what happens in the political dimension and what happens in the jurisprudence of our course. And I have a couple of references later on to show this. The reach and degree of review is, of course, also different. In Norwegian law, there has not been any adjudication the way you've seen in the Danish context of competences between state bodies, and generally there hasn't been much of that in Denmark either, because there hasn't been much in Denmark of court review. Obviously, we have been interested in to learn more about Icelandic practice, and we always have to discuss that. One reason in the Norwegian constitutional context was that because you kept, you actually used. Of course, we know from the American system as well that you have a particular political court which has representatives from the Senate and from the Supreme Court. For impeachment proceedings, we have that too. But to some extent, Olmsted said that this is the court to resolve those issues. But of course, it's a criminal court, like an impeachment court. But that has been one of the arguments. Also, we are a unitary and not a federal system, which means that we have less of those competence conflicts. We have a parliamentary system, so at the same time, in parallel with court review, judicial review developing, we get the parliamentary system. And when you have a unitary system with parliamentary control, there's less reason for these kind of institutional conflicts. They will not go on to adjudication by a court altogether. The parliamentary majority controls the executive. There's no precedent. There's no rights are protected in the Constitution. And I think you showed very well the way that has differed. But of course, the Norwegian situation is different in the sense that one had a small, compact rights catalogue, including also freedom of the press, from 1814 onwards. Carsten Smith, a law professor in 1974, proposes a graduated intensity of review. And that is again, if you like, the second big borrowing from the US, because it's then looking at the Supreme Court's practice on differentiating between the rights. You know? So typically, if there is a prohibition against torture, a prohibition against arbitrary detention, those are personal rights. Whereas when it comes to, and here he does not necessarily distinguish between civil rights, because of course property, retroactivity ban are all in the first generation of civil rights, and he says those rights should be less protected, in the sense that there should be a greater discretion for the legislator. So protection of personal integrity given more effective protection than economic rights. Then I have a long part here, which I'll rush a little bit, on because there's an interaction between human rights constitution and the European Convention, of course, which has been very important. And in the 1990s, the Scandinavian countries adopted the Human Rights Acts. What we did in Norway was that we got the constitutional provision, 110C, which then says the state has to observe the human rights, which it is obliged to observe through international treaty obligations. And then we got the Human Rights Act just after that in 1999, stating that the international treaty obligations take direct effect through a particular procedure, and the courts could set aside. It's a duty on the whole public administration, but the court can set aside domestic legislation if it contravenes these human rights conventions. And in the Norwegian context, quite a wide range of human rights obligations were incorporated in through this 1999 Act and the follow-up legislation. So it includes not only the European Convention, but the ICCPR and the 266 UN conventions, Convention on the Protection of the Rights of the Child, the Convention on the Women's Convention, and that then creates a somewhat different situation from many other European countries, like for instance the Human Rights Act in the UK only looks at the European Human Rights Convention. But I say a bit more about this, but I'll also come back to the issue of has one any particular threshold? Is there a certainty, clarity, manifest threshold before you set aside legislation? I'll come to that in a little while, because that's been the most controversial. But then, of course, going then into to say a bit more about the rights in domestic constitutions. I think I covered that in the introduction well enough, but I'll continue with that in a little while, because there is an ongoing reform process, of course, there, which has been particularly interesting. Now, what have they done in their case law? Well, the Scandinavian courts have all emphasized the royal implementation of the case law. There's been no conflict where they have said we will not follow. And some of the language used by the UK Supreme Court, all has the lords, making it a bit uncertain, should they ever resist, or if there was a conflict between what the legislators said in ordinary legislation and, well, here you've got constitutional basis and a different kind of hierarchical laws approach. So it's easier for the Scandinavian Supreme Court to say we will not follow the legislator, because particularly in the Norwegian context with the Constitutional Amendment and the Human Rights Act, you can say that this clearly establishes a hierarchy. However, of course, in practice, the UK Supreme Court has now established a very clear hierarchical approach. It is not imaginable today that they would follow legislation. It will require such certainty and clarity in the legislation itself for Parliament wanting to abrogate from the European Convention. So that's not, one shouldn't make too much out of these differences. The big issue in the Scandinavian courts, particularly the Norwegian and Swedish courts, have been linked to this threshold. They try to introduce them in argument before the court. So, first of all, in the Swedish new catalogue of rights, which was adopted in the 1990s, well, that was a modern, wide, and it started in the 1970s, and there was a process which was completed in the 1990s. They had the last round, which with constitutional amendments, which took effect in 2011, is it, or 2010? 2011. So, and when they introduced this new rich catalogue in the 1990s, completion, if you like, of this first stage of domestic constitutional rights reform, they also introduced, as you mentioned, an express provision about court review. And that stood out because you can imagine with the Aspen and Dale and the 1950s discussion, this was by this stage, it had been reached a general political acceptance of rights being something which should be protected. The whole range of rights should be protected in principle, and also that the rights should be used by courts, and legislation should be subject to courts' rights review. But then they introduced a provision saying that the breach of human rights standards had to be clear or manifest. What is the term I'd like to use here? Because it's not manifest in the European Human Rights Court's meaning, but it is a requirement of it being a clear breach. And that would mean two things, of course. You would have to establish clarity when it came to the constitutional right. And you have to establish clarity as to the domestic legislation breaching the constitutional right. So it could give the court a lot of scope. And the idea was then that the courts had to show deference to the political decision-making process. So that was it. However, in the discussion, you found it very difficult to give direct effect, no clarity, manifest certainty relating to European Union law. And European Union law was, of course, economic law. If you then should have this higher threshold for core human rights, if you like, arbitrary detention, torture, that was seen to be ideologically unacceptable in the Constitution. So, however, what happened was then that the Swedish courts then applied this extra threshold in their case law relating to the European Convention on Human Rights. So, this extra threshold which applied to the application of or the review of domestic legislation on the grounds of the domestic constitution and its rights was also applied to the European Convention. But they could not, of course, apply to European Union law. It was a minority of judges who then said, we cannot have this. We must give the same effect to European Convention rights as we do to European Union law. And no matter what it says in the Constitution about constitutional rights, domestic constitutional rights, you have to give effect without this extra threshold. They remain a minority, but this was a very long discussion, so that when the Swedish lawmaker, after quite an extensive process, then decided to take out this threshold, this extra threshold of clarity, manifestness, or whatever it was, in 2011 amendments. Now there's a review without any extra threshold for Swedish domestic constitutional review. The courts have, with reference to the parliamentary process, assumed that this also will have an effect on the European Convention. So now there's no extra threshold when it comes to applying the European Convention in Swedish law. In Norway, this was a very complicated. I have some cases on my handout later on, but basically for a short period, the Norwegian Supreme Court said it had to be a clear breach, but it overturned its own doctrine. There was a very convoluted legislative process because in government you had some people in the Ministry of Justice in particular and in the Prime Minister's office who did not want a constitutional amendment about human rights, who did not want the Human Rights Act, and today do not want the current proposal for constitutional rights reform. And these individuals in government tried through the legislative process and through their government submissions in cases before the Supreme Court to influence the process, and I'm afraid well supported by some academic colleagues on a very flawed legal basis to have established this clarity doctrine. But the Supreme Court, after some period, then rejected it. I thought I should also just add that when we assume dualism, when it comes to the application of European Human Rights Convention, I'm a bit critical of the dualist doctrine because I don't think, where is it? Do the constitutions say we have a dualist doctrine? No. Do courts say it? Well, yes, now and then, not consistently. And in Norway, there was a challenge to the dualist doctrine. So all our great judges who wrote, 3 Supreme Court presidents, and all our great public and constitutional lawyers said there wasn't really a dualist, general dualist principle. If there was a dualist principle, it would not apply to fundamental human rights obligations. But Supreme Court practice is not absolutely consistent, and there are several issues there, but to assume that we are a dualist system, at least for the sake of Norway, is problematic. You cannot automatically do it, and it has to be analysed further. And then anyway, what do you mean by dualism? Is it a general principle of dualism which has been cut through by constitutional provisions about human rights, by legislation, giving effect to international obligations? Well, in the Norwegian system then today, basically, if it were a general principle, it has been limited in so many ways that you wonder, is it meaningful to talk about a general principle in Norway? And I think this applies, well, it clearly applies to our context, and I know how some international lawyers, not so many international lawyers, but some international lawyers, and most constitutional lawyers are very strong on this, but the meaningfulness of a dualist principle at least can be challenged in the Norwegian context, and I think in most systems today it's an old-fashioned concept which I'm not willing to accept as a general principle. I just say a little bit about these different phases, and I thought that Jean-Louis, in a way, you summarized it so well, so I will just basically add to your analysis that really we have had not only the control of foreigners' rights to waterfalls, that's the waterfall case. It's about, one, saw it as a problem that foreign interests would buy up all the waterfalls and hydroelectric power being a great value. One wanted to restrict their rights, and that went on as a very complicated process with interaction between the legislature and the Supreme Court, and the final judgments of the Supreme Court, then passing, or letting the legislation pass the review is then ending, if you like, the first phase. Now, there were a number of rights conflicts in the early 1950s. There were two sets of conflicts. There was one set of political or rights concerns seen from the right, and those were the interventions through new regulatory legislation into property rights and the exercise of economic or business activities. There was rights concerns seen from the left, and that was in the context of emergency legislation, which was discussed in all the Scandinavian countries. It's parallel discussions, but this took particularly sharp form in the Norwegian context, where we had this kind of rights discussion seen from the right and the left at the same time. It never reached the courts. And it became generally a political discussion. But what was interesting was that the radical intervention into rights failed. It never reached the constitutional level. It never, because the legislation was not adopted. I'll do two more minutes. Just to fill in what you said about interaction in the Supreme Court practice when it comes to the domestic rights in the Constitution and the European Convention. We have a number of interesting cases which illustrate this very well. Basically, the Article 6 cases, which you also touched upon, have shown that the Supreme Court, and I think basically what happens in some cases is that you get the majority for an outcome in the Supreme Court, and these cases will be heard in the Norwegian Supreme Court in a grand chamber or a plenary, which means that there will be more than 10 judges, 12 or 18 judges. So it's a big court, whereas otherwise they would normally sit in a smaller chamber of 5. So that then you count majorities in different ways. And I think in some cases, this is not clear from the judgments, but in some cases you then set aside legislation and there's no majority to do it on the basis of the European Convention. There's no clear enough constitutional principles in domestic law, or constitutional provisions anyway. So what you have done is you have developed principles. So you now, and this is interesting comparison with the French discussion of principles, of course, constitutional principles. They do not necessarily call it constitutional principles, they just say principles. And it's clear that it is something that avoids a contravention of the European Convention and avoids possibly a contravention of the domestic constitution, but you take it on the basis of principles. Otherwise, one has not been particularly good in developing the domestic constitutional rights in light of the European Convention. The one area where it has happened is in relation to freedom of expression and Article 100 of the Norwegian Constitution, where they will start off very often discussing Article 100 of the Constitution, and then the actual determination of the legal issues will be based on the jurisprudence of the European Human Rights Court. However, otherwise, they are not done. And one reason for this is also the academic discourse, because the constitutional lawyers regard Eivind Smith, who's not the first, C. Smith, Carsten Smith, who borrowed from you, he afterwards became president of our Supreme Court. Eivind Smith has remained at university, E. Smith, and he's, I think, our leading domestic constitutional lawyer today, and his view is that you cannot use the European Convention as anything else but comparative law. You know? So therefore, that kind of doctrinal bar has made it difficult for them to develop. And then again, the academic community in Norway is extremely interesting. As we all know, law professors are traditionally conservative in the sense that they're against change, and conservative also to some extent that they would traditionally defend established positions. It's the nature of law and the nature of academic communities in most countries. In the Norwegian context now, it's also mixed with a very strong, I can say, nationalist tradition, which then means also that many of the lawyers' tradition on the left will feel that they should fight or resist international courts and international obligations. So every single Supreme Court decision giving effect to rights, defending a criminal defendant, or for that matter a privileged position, when it's property law, will be met with pretty unanimous academic criticism. It will be dealt with in the textbooks in a moderately loyal way, but the academic discussion is extremely critical. And that goes to every European court decision, being the European Human Rights Court, which can have effect on the Norwegian system, or any European Union Court decision, which can have an effect on, say, union rights, etc. We were met by the same pretty unanimous critical discussion. I have a lot to say about these decisions, which we may have some other occasion to do, and anyway, I'm writing out the paper, because this was a great inspiration. Thank you.
We have to decide perhaps about the planning, because we must leave the classroom at 12.
Let's make a point just to start. This lecture, this presentation of the situation in the UK comes from a French lawyer, so it's an outsider point of view. So I want this to be clear first, because I'm not at all, or not anymore, an insider, as I would say. So I think it's very important to say this first, and to acknowledge the fact that I will present the state of the debate right now. It's not a historical review that I want to make here. In a recent public lecture in London, it was last week, Neil Walker, professor in Edinburgh, analyzed numerous causes of troubles in UK constitutional references. The title of his lecture was kind of scary. It was Our Constitutional Unsettlement. This phrase tends to put forward instability as a feature of a UK pseudo-constitution. And indeed, current reality is full of illustrations of this unsettlement, ranging from territorial causes like devolution question and EU commitments, to institutional causes such as the new Supreme Court and the ongoing constitutional reforms